Hello friend, how are you? I am advocate Gaurav Kumar Gupta. I am chartered accountant and MBA finance and PhD holder. My project derivative market future trend analysis. आज हम टॉपिक डिस्कस कर रहे हैं व्हाट डू यू अंडरस्टैंड बाय डाइन डिक्लेरेशन व्हाट इज द evidentiary value it is a piece of substantive evidence. Dying declaration, the title of section 226A, is when it is relates to cause of death according to this section. When the statement is made by a person as the cause his death as to any of the circumstances of the transaction which resulted in his death. In case in which the cause of the person death comes into question, such treatment are relevant whether the person whom made them was not was a person that comes into question. Such treatment are relevant whether the person who made them was or was not at the time when they were made under the exception of death, and whatever may be the nature of the proceeding in which the cause of his death comes into question. A dying declaration means that the statement of a person who had died explaining the circumstances of his death. According to English law, the statement is relevant only when the charge is that of murder, manslaughter. This was let down in R.V. Mead, the accused, who had been convicted of perjury, giving of false evidence, obtained an order for new trial before this could take place has sought dead on of the witness. It was sought to prove at the new trial a declaration of the deceased, witness given before his death in which he stated certain fact material to the charge of perjury. Evidentiary value of dying declaration. Dying declaration का evidentiary value क्या? The statutory authority in section 26A itself, the judicial authority is the leading decisions of the Privy Council in Pakkalan Narayan Swamy versus King Emperor. The wife of the accused was indebted to the deceased in the sum of rupees to 3,000, which she had borrowed at 80% interest from the deceased on account of their needs about a year before. The tragedy, a member of letter is signed by the accused wife, which were discovered from the deceased house clearly proved this fact. On 20 March 1937, the deceased, whose name was Kian, received a letter which was not signed by anybody but which it was reasonably clear had come from the accused wife. Invited him to come that day. Next day, the Brahmpur KN window told the court that on that day her husband saw her a letter, said that he was going the Brahmpur as the Swami wife had written to him inviting him to come to receive payment of his dues. KN, the wife of the accused, were none to each other as she was the daughter of an officer in whose office KN was employed as a peon. KN left his house the next day in time to catch the train, the Brahmpur, on Tuesday, 23rd March. His body, cut into 7 pieces, was found in a steel trunk in the third class compartment of a train at the Puri, where the trunk had been left unclaimed. The accused was convicted of murder and sentenced to death. The evidence against him was firstly his indebtedness the deceased. Secondly, the statement of the deceased to his wife that he was going on the accused. Thirdly, the steel trunk was purchased by a Dhobin washerman for and on behalf of the accused. Some other detail about the arrival of the disease at the accused house, the discovery of blood stain, cloth and transportation of the cloth stains and transportations of the trunk to the station were also proved that the accused appealed to Privy Council on the ground that the statement of the DG to his wife that he was going to the accused was wrongly admitted under Section 26 Clause A, that the statement the accused to the police that the DG arrived at his place was admitted in violation of 181 of BNS भारतीय नागरिक सुरक्षा 2023 referring to the first argument. Lord Lord Atkin said a variety of questions has been mooted in the Indian courts as the effect of this Section 26 Clause A. It has been suggested that the statement making it must be at any rate near death, that the circumstances can only include act done when and where the death was caused. Their lordship are of opinion that the natural meaning of the words used do not convey any of these limitations. The statement may be made before the cause of death has arisen or before the disease has any reasons to anticipate being killed. The circumstances must be circumstances of the transaction, general expression indicating fear or suspicion whether of a particular individual otherwise and not directly related to the occasion of the death will not be admissible. But statements made by the deceased that he was proceeding to the spot where he was in fact killed, as to his reasons for so proceeding, that he was going to meet a particular person, that he had been invited by such persons to meet him, would each to them be circumstances of the transaction, and would be so whether the person was unknown was not the persons accused. Such a statement might indeed be explanatory of the person accused. Circumstances of the transaction is a phrase, no doubt, the convey some limitation. It is not a broad as the analogous using circumstances evidence which includes evidence of all relevant fact. It is on the other hand narrow. The regesty circumstances must have proximate relations to the actual occurrence. It is a piece of substantive evidence. The principal laid down Pak, Pak, Pakala case relating to the relevancy of dying declaration were accepted by the Supreme Court in Kausal Roy versus State of Bombay 1958. There was two rival factions of workers in a mill area in Nagpur. Rival factions even attacked each other with violence in one of violence attack on the Babu Babu Lal was inflicted a number of wounds in the street at about 9 p.m. He was taken to a hospital by his father and other reaching there 9 9.25 on the way he told the party that he was attacked by four persons with swords and spears, two of whom he identified, Kausal and Tukaram. The doctor in attendance immediately questions him and recorded his statement in which repeated the above two names. A sub-inspector also questions him and noted him a statement to the same effect by 11:35 p.m. A magistrate also appeared after the doctor had certified that the injured was in fit conditions to make the statement. The magistrate recorded the statement, which was again to the same effect. He died the next morning. On the basis of this declaration recorded in quick successions by and independent and responsible public servant as corroborated by the fact that both the named persons were absconding before they were arrested. The trial judge sentenced Kausal to death, Tukaram to life imprisonment. The High Court acquitted Tukaram altogether because of the confusions caused by the fact that in the dying declaration he was described as the Teli daily whereas Tukaram present before the court was a Kohli in the same locality therein he lived for person bearing the same name, some of whom were the Talis. But the convictions of Kaushal was maintained, and on appeal the Supreme Court also affirmed the conviction. Sinha J. Afterwards, CJ did not consider it to be absolute rule of law that a dying declaration must be corroborated by other evidence before it can be acted upon. The learned judge had to face the following observation. The Supreme Court itself. It is settled law that it's not safe to convict an accused person on the evidence furnished by a dying declaration without further corroboration, because such a statement is not made on oath in is not subjected to the cross examinations and because the maker of might be mentally and physically is a state of confusion. This statement occurred in case which the murder took place in dark night and there were no light available at a place, and therefore the court ruled that the declaration and questions was not dependable. Sinha Sinha J. therefore pointed out that the observation, being unnecessary for deciding the case, was arbitrary and did not have the force of law, and they continued. The legislature, it is the wisdom, as enacted Section 26 Clause A of Evidence Act, thus the statement by persons who is died is itself a relevant fact. This provision has been made by the legislature, advised as a matter of sheer necessity by way of an exception to the general rule that hearsay is no evidence, and that evidence which has not been tested by cross examination is not admissible. The purpose of cross examination is to test the veracity of the statement made by a witness in the view of the legislature. The test is applied by the solemn occasions when the statement was made, when the person was in danger of losing his life. At such serious and solemn moment, that person is not expected to tell a lie. How for fact Bad character is relevant to show the probability to commit crime. Explain the light of section 12 and 49 of the भारतीय साक्ष्य अधिनियम BSA 2023. फैक्ट ऑफ बैड कैरेक्टर इज रिलीवेंट. अगले वीडियो में हम आपको फैक्ट ऑफ बैड कैरेक्टर रिलीवेंट अकॉर्डिंग टू सेक्शन 49 ऑफ इंडियन एविडेंस एक्ट के बारे में जिक्र करेंगे, जिसको हम भारतीय साक्ष्य अधिनियम 2023 से रिलेटेड करते हैं. आज का वीडियो हम क्रॉस डाइंग डिक्लेरेशन के बारे में डिस्कस किए हैं कि डाइंग डिक्लेरेशन होता क्या है. इसका वीडियो आप हिंदी वर्जन में भी इसका हम एक्सप्लेन करेंगे अगले वीडियो में. आज का वीडियो यहीं पे वाइप आउट करें. डेट्स ऑल.